Assalamualaikum and good morning, doctor. My name is Masharada. Today, I present introduction. Contract law is important because it regulates agreement between two or more parties and ensure that these agreements are legally valid. In Malaysia, it is covered by the Contract Act 1950, which outlines how contracts are formed, carried out, and terminated. One key concept is the discharge of a contract, which refers to the termination of contractual obligation. This can happen in several ways, including by performance, agreement, fruition, or breach. Among these, breach of a contract is the most significant because it occurs when one party fails to fulfill their obligation. When a breach happens, the affected party has the right to seek legal remedies in Malaysian law. These remedies include damage, specific performance, injunction, and rescission. These are applied by the court to ensure fairness and to protect the right of the parties involved. Overall, contract laws play a crucial role in ensuring justice and maintaining trust in agreement. Thank you.
Good morning and afternoon, Doctor. I'm Chui Sin. I will explain discharge by performance and discharge by agreement under Malaysian contract law. The first one is discharge by performance. It happens when all parties successfully fulfill their contractual obligation. According to Section 38(1) of the Contracts Act 1950, parties must either perform or offer to perform their promise. And there are two types of performance. The first one is actual performance, where both parties completely fulfill their obligation. The second one is attempt performance or tender, where one party is ready to perform but the other party refuses to accept it. Discharge by agreement occurs when both parties mutually agree to end or modify the contract. Under Section 33 of the Contracts Act 1950, parties may waive or change contractual obligations, and this can happen through rescissions, novations, alternation, and waiver.
Hi everyone, my name is Ahmad bin Muhammad Pabi. You can call me Yadi. Okay, today I will continue our group presentation and I will present about discharge by fruition and breach of contract. Okay, let's look at fruition. Fruition happens when an expected event make a contract completely impossible or unlawful to perform. It might be nobody's fault. Okay, under Section 57(2) of the Contract Act 1915, the contract ultimately become void. For example, include when an item is discharged, new law are passed off because of death and illness. For example, imagine Yazid promised to lend his mountain bike to Haikal, but lightning burned the bike at night. The contract is frustrated because the bike is gone. In case of situation here, Kerajaan Negeri Sembilan, 2021, the court said the call for frustration is very high. It's not frustrated just because the job become difficult or costless. Let's move to the next slide. Okay, now let's look at breach of contract. Okay, a breach happens when one.
Assalamualaikum and good day to Dr. Sabri and my fellow friends. Today, I will present about legal analysis, Part A, ground for discharge and the legal mechanism of breach. I will explain the 4 ways to end a contract in Malaysia under the Contracts Act 1915 using the IRAC method. First is discharge by performance under Section 38, Subsection 1. The rule says a contract ends when both sides finish their duties perfectly. However, the case of Sarah and Hussein 2023 shows that substantial performance is also accepted. This means if the main job is done with only minor mistakes, the contract can still end safely. Second is discharge by agreement under Section 63. The rule is that parties can change or cancel the contract if both sides agree. In the case of Peminaan Legenda Unggul 2021, the High Court decided that the actions and mutual understanding of both parties are enough to change the contract and they do not need a new formal agreement. Third is discharge by frustration. Under Section 57, Subsection 2, this happens when an unexpected event makes the contract is impossible or illegal to do. In the case of PSI in Control 2022, the court said the rule is very strict. Just because a project becomes harder, slower, or costs more money, it does not mean the contract is frustrated. Fourth is discharge by breach under Section 40. This happens when one side refuses to do their job completely. In the case of Lundin Energy 2023, the court confirmed that if one party shows they cannot follow the rules, the innocent party has the right to stop the contract and immediately ask for remedies like compensation. In conclusion, Malaysian law protects both business certainty and fairness. The courts will check the facts carefully to decide how a contract ends. That's all from my part. Thank you.
Assalamualaikum to Dr. Sabri and everyone. My name is MOHAMMAD ZAMRI. Today I'll be presenting part B of our legal analysis, focusing on the typology of available legal remedy under the Malaysian Contract Act. Let's start with section 74, which deal with unliquidated compensatory damage. The core legal here is proving the causation and remoteness for an innocent party to successful claim loss. The law established a strict two-limb test under the rule of Hadley versus Baxendale. For the first limb, the loss must arise naturally in an unusual cause of thing from the breach. Second limb, if the loss is special or indirect, it is only recoverable if both parties actually knew about likelihood of such a loss when they made the contract. Now let's contrast this with section 75. This section is designed to make business interaction much simpler. Instead of wasting time and money fighting over messy and alleged calculation after a breach, party pre-agree on a fixed compensation sum right inside the contract. Furthermore, under the older case of Selbah Kumar, Malaysia court still required the innocent party to strictly prove they actually lost before they could touch the agreed sum. However, the legal landscape shifted dramatically with the landmark federal court case Cubic Electronic versus Mars Telecommunication 2019. Once a breach of contract is proven, the pre-agreed let clause is automatically enforceable. The agreed sum itself is enough to claim and provide it remain reasonable. In conclusion, Section 74 required rigorous proof of natural losses, while Section 75 offers a streamlined efficiency shortcut for commercial certainty. That's all from me. Thank you.
Good morning, Dr. Sabri. My name is EZEKIEL, son of MURALI. Today, I will critically evaluate the stark divide between academic contract theory and judicial reality in Malaysian courtrooms. First, under Section 74, securing compensatory damages is a severe practical hurdle. Courts strictly reject speculative claims, enforcing an uncompromising evidentiary burden without precise, mathematically quantified documentary proof like invoices or audited accounts. Plaintiffs receive near nominal damages, leaving small businesses systematically undercompensated. Similarly, for equitable remedies, courts routinely default to monetary awards instead. This stems from strict judicial restraint and a reluctance to assume the heavy administrative burden of constantly supervising ongoing commercial activities. In contrast, Section 75 represents a massive modern victory for commercial pragmatism. The old Selbah Kumar position frustratingly forced plaintiffs to prove actual losses anyway, rendering LAD clauses useless. Fortunately, the landmark Cubic Electronics ruling fundamentally reversed this. The burden now shifts entirely to the defaulter to prove the clause is unreasonable, drastically accelerating judicial efficiency. To conclude, while our statutory framework is robust, its real-world efficacy faces key weaknesses like high litigation costs and rigid proof standards. Ultimately, true contractual protection relies far less on a courtroom bailout and far more proactive, preventive drafting. Thank you.
Good morning, Doctor and my fellow friends. My name is CHIAN from BTN Session 2. I will continue present part recommendations. One of the recommendations are strengthening public awareness and contractor literacy. This is because many individuals or businesses enter contracts without fully understanding their legal rights and obligations. Besides that, parties should ensure that contracts are clear, detailed and comprehensive. This is because a properly drafted contract can reduce ambiguity and minimize future disputes between parties. Furthermore, alternative dispute resolution methods such as mediation, negotiation, and arbitration should be promoted more actively in Malaysia. ADR provides a faster, more flexible and less costly approach to resolving contractual conflicts, while preserving business relationship between the parties. In addition, Malaysia's court should continue improving consistency in the awarding of legal remedies. Although remedies such as damages, injunctions, and specific performance are available under Malaysian law, judicial discretions may sometimes lead to inconsistent decisions. Moreover, the law should continue protecting innocent parties who suffer losses due to a breach of contract. Fair and effective remedies are important in maintaining confidence in contractual relationships and ensuring that parties fulfill their obligations responsibly. Lastly, parties involved in contractual relationships should practice good faith, honesty, and ethical conduct throughout their dealings. Ethical business practices and transparency can reduce the occurrence of intentional breaches and strengthen trust between contracting parties. That's all for me. Thank you.
In conclusion, Malaysian contract law plays an important role in protecting contractual relationship and ensure fairness between parties. Under the Contract Act 1950, contract may be discharged through performance agreement, frustrating, or breach, depending on the situation. Among this method, breach of contract is particular important because it allows the innocent party to seek legal remedies. These remedies including damage, specific performance, injunction, and other form of legal relief. Malaysian court carefully assess each case to ensure justice and fairness are achieved. Overall, contract law help promote certainty, accountability, and trust, which are essential for stable commercial and personal transaction in Malaysia. For Q&A section, I got two questions. First one, slide 5 and 9 touch upon two type of breach of contract under Section 40, actual breach and anticipatory breach. Can you explain the difference in legal recourse available to innocent party between these two type of breach? Okay, my answer is the primary difference lies in when legal action can be initiated. Actual breach, the breach occur on the actual deadline of contract, such as the case of Afiq bin Zakaria versus Berjaya Times Square Hotel in 2036, where the hotel failed to provide the confirmed booking on scheduled day. The innocent party can immediately terminate the contract and claim damage at that exact moment. Anticipatory breach, one party and implicitly state or implies through their conduct that they do not intend to fulfill their contractual obligation before the deadline arrives. Under Section 40, the innocent party that has two legal options when they can either select to resign the contract immediately and sue for damage, or they can choose to ignore the repudiation treat to contract as still alive and wait until the deadline to see if the other party changes their mind and performance. And the second question that I got, according to slide 12, under equitable remedies, is not the court are reluctant to supervise ongoing business activities and generally refer to monetary damage. Why do court adopt this approach in commercial case? So my answer, equitable remedies like specific performance are discretionary remedies granted by the court and are not absolute right. So courts are generally hesitate to grant specific performance for ongoing commercial operation, such as ordering a firm to construct a housing project or run a daily service, because it demands constant and rigorous judicial supervision to ensure compliance, and court do not have the logical resource of time to oversee day-to-day business operation. Therefore, court generally deem to monetary damage to be an adequate and more practical remedy. Specific performance is usually reserved for unique asset or transaction involving land, where monetary compensation cannot adequately replicate the unique nature of the property. Thank you.